Welcome to the NC Injury Rights Podcast.
Welcome back to the North Carolina Injury Rights Podcast with Mehta and Jason McConnell, where we break down workers' compensation issues for North Carolina workers injured on the job. Vero and Jason are co-founders of Mehta McConnell, PLLC, a Charlotte-based law firm focused on representing injured workers across the state. Both began their careers representing employers and insurance companies before shifting their focus to helping injured workers understand how the system actually works. I'm Evan Mack, and today we're talking about independent medical exams, often called IMEs, what they are, why they happen, and how they can affect workers' compensation claims. Gentlemen, welcome back.
Thanks, Evan.
Thanks, Evan. Good seeing you again.
Good stuff. Good to see you guys as well. So let's start it out. For someone who's never dealt with one before, what is an independent medical exam and why are injured workers required to attend them?
Well, it's sort of interesting. Vera and I were talking about this before we started recording. So there's two kind of methods in North Carolina for an injured worker to undergo either an evaluation with a physician that is otherwise not his authorized treating physician. There's typically the way it works is from the plaintiff's side, if you would like to get the perspective of a physician who is not your authorized treating physician, we would request what's called a second opinion evaluation, a comprehensive second opinion evaluation. And there's a statute in our Workers' Compensation Act that has a process wherein we can do that. Independent medical examinations really are from the insurance company's point of view. And they can happen whether the claim is accepted. In North Carolina workers' compensation cases, accepted workers' compensation claims, the insurance company has the right to direct medical care, meaning they get to choose your doctor, they get to choose which facilities you go to for MRIs or physical therapy, and they really direct and control your medical treatment. But sometimes the authorized treating physician that they assign you, for whatever reason, maybe they're not happy with the state of your treatment. So they might refer you out to an independent medical exam under 9727 in our statute. Other cases, your claim can be fully denied, but they can still require you to attend an independent medical examination just to get an opinion on your medical status and also causation, whether your alleged workers' compensation accident caused the injuries which you're complaining of. So when we talk about IMEs, what we're really talking about is a tool of the defense and the insurance companies to kind of, either build the case for their defense or to figure out a quicker way to basically wrap up your medical treatment and return you to work.
So Vero, despite the name, many workers question how independent, an IME really is. Who selects the IME doctor and how does that influence the process?
Good question, Evan. The insurance company selects the IME doctor, and so that can give you all the information you need to know about just how independent or lack thereof an IME is. The insurance company is naturally going to select a doctor they like, okay, a doctor they've had past experience with, they've seen in previous claims, who they feel has given them favorable medical opinions. So they're going to tend to choose a defense-friendly doctor. And so it is important for an injured worker to know going into these things, going into an IME, that it is not going to be independent and that it is going to be somewhat of an uphill battle, and that therefore it is a good idea to consult a lawyer about an IME and about the next steps in their case.
Jason, from the insurance company perspective, what role does an IME play in a workers' compensation case?
Well, like I said earlier, typically they're using the IME as a tool to either put pressure on the authorized treating physician to undertake a certain type of treatment, maybe speed up the treatment that the authorized treating physician may otherwise be providing, or in denied cases, like I said, they will be using the IME as a tool to help them argue against causation in a workers' compensation claim, to ultimately hope that the industrial commission finds that the claim is not compensable.
Mhm. So Vera, what should an injured worker expect during the IME appointment, both in terms of the examination itself and the questions they're likely to be asked?
There's a long statute in the North Carolina Workers' Compensation Act, General Statute 9727, that covers IMEs, Evans, and it is very detailed. Again, it's a good idea to talk to a lawyer before presenting for an IME. But one of the things it says is that anything an injured worker says to the IME doctor is not privileged. So a lot of times our clients are used to a concept of patient-physician privilege. That doesn't apply in an IME. So um, that is very important for an injured worker to know going into an IME as to exactly what they're willing to share with an IME doctor, because that is going to be likely in a medical report that can be shared with the defense, et cetera. So these are uh, unique appointments that differ from the standard medical treatment in a workers' compensation claim. As far as questions that they'll be asked, oftentimes the insurance company or their lawyer will write a letter to the IME doctor with the issues or they want addressed during the IME or questions they want answered. So the IME doctor will go off that letter and ask the appropriate questions to the injured worker to address the issues in the case. For example, if there's an issue of medical causation, the injured worker may get asked questions about their prior medical history, about the mechanism of the injury, things like that. If there's a question about whether surgery is necessary or not, there might be questions about pain level, again, whether there's any prior problems to that injured body part. So, again, the questions are going to vary and they're often going to be guided by the issues to be resolved in the case, and the issues asked by the insurance company of the IME doctor.
So Jason, what mistakes tend to cause the most problems, for workers before, during or maybe even after the IME?
Well, I think mistakes that injured workers often make, not only at IMEs, but also with their authorized treating physicians, is most people, I think, have a tendency to downplay the severity of their injuries or the amount of pain and discomfort that their injuries are causing them. Oftentimes, when you're dealing with an IME physician, it's a doctor that you're only going to see on one occasion. It's at a practice that you're not familiar with. The individual is really not there to establish attorney or patient-client, relationship. So the doctor's bedside manner may be a little bit more, I guess, gruff would be a good word, because the doctor is there to do a job for the insurance company and the defense. And so when people have those types of interactions, they tend to kind of, not be as forthcoming about their injuries or the problems that they're having as they otherwise would with a doctor that they already have a relationship with. So I always tell my clients, in cases where an independent medical evaluation has been scheduled, you really need to advocate for yourself, first of all, because you're going to be alone there in that examination room. Although there is a provision in the IME statute that allows you to bring a physician with you to the IME. It's just that's a very cost prohibitive type of thing to do. So you're going to be the only voice that IME physician is hearing. So don't downplay, your injuries and your discomfort and the issues that you're having. If anything, you want to sort of amplify those things, because the IME physician is certainly going to be downplaying what you tell him in his report.
Mm. So Vera, how much weight does an IME's doctor report carry when it comes to those decisions about medical treatment, wage placement, or maybe those disability benefits they might receive?
Evan, when there's conflicting evidence, especially conflicting medical evidence, ultimately the industrial commission is going to make the final decision as to which doctor they believe. Okay, so for example, if a treating physician says an injured worker needs surgery, but the IME doctor says, I wouldn't recommend surgery. Um, Ultimately, if there's a dispute between those two, the industrial commission will decide whether or not the injured worker gets that surgery, whether the insurance company is ordered to pay that surgery or not. Same thing. If a treating doctor says an injured worker has work restrictions of no lifting more than 25 pounds, while an IME doctor says there are no work restrictions that I would recommend, again, that's a big conflict. And ultimately, the Industrial Commission would decide, which doctor to give the most credibility to. As an advocate for injured workers, I would argue zealously that the treating doctor who has seen the injured worker throughout the course of their treatment, likely has seen them since immediately after their injury, should be given greater weight because they have a better understanding of the injured worker's medical condition, as compared to an IME doctor who has only likely seen that injured worker one time for maybe 30 minutes. Okay. So that would be our argument on behalf of the injured worker. But the Industrial Commission makes the ultimate decision. And it's important to note that the insurance company is going to use that IME's doctor's opinion, especially if it's more lenient or more favorable to the insurance company. And they're going to argue that those medical recommendations, those work restrictions should control as opposed to a treating doctor. Now, sorry to be a little long-winded, Evan, but the good thing about this sometimes is if the IME doctor agrees with the treating physician, at that point, it really backs the insurance company in a corner. It's very hard for them at that point to continue denying treatment or to continue arguing that an injured worker is not disabled if both the treating physician and the IME doctor agree. And that does occasionally happen. You'd be surprised where the IME doctor sometimes makes the case for us as advocates for injured worker, where now you have two doctors saying the same thing.
Mm. So Jason, can an IME, report conflict, with or override a treating doctor's opinion? How does that situation usually unfold? Is it a little bit like Viral said, or have you seen other things as well?
Yes, it can override an authorized treating physician's opinions. Like I said, or like Viral said, it's usually up to the Industrial Commission to weigh the opinions of the treating physician. Interestingly, if you look at the history of the IME statute in North Carolina General Statute 97-27, back before 2011, which was significant because our Workers' Compensation Act underwent a pretty significant revision. The IME statute was actually a lot more neutral. In fact, part of the statute said that if the defense insurance company requires you to undergo an independent medical examination, you have the right to have another independent medical examination with a physician of your choosing paid for by the defendants. That's part of the statute was revised in 2011 to say that, well, you don't get a right to a full second IME. You get a right to a revision or a second opinion on permanent partial impairment ratings. And anything else that second opinion or second IME doctor says really doesn't have any bearing on your claim. So it's up to the Industrial Commission to determine how much weight the IME holds, depending on whether it's favorable or not to the defendants. Of course, the insurance company is going to argue that either has a lot of weight or it doesn't have a lot of weight. But ultimately, the Industrial Commission has the discretion to take all the facts and all the medical evidence into account before rendering a decision on the medical causation issues.
So Viral, how should injured workers prepare for the IME in a way that protects their claim without appearing uncooperative or maybe even dishonest?
I always tell my clients, Evan, there's a middle ground. You can be firm, you can be an advocate for yourself without coming off as argumentative or abrasive. Okay. And one of the good ways to prepare for an IME is to talk to a lawyer who can give you guidance, who can coach you up on what to say. And oftentimes, for our clients who are required to go to an IME, we will write a letter to the IME doctor giving our client's point of view, which makes it a little bit easier on our clients because now they can take a letter with their, position about their injuries to the IME doctor, and it takes a little bit of the stress off of their plate where they don't have to worry about coming off as argumentative or uncooperative. They can do less of the talking and let that lawyer do the talk, or let the letter written by the lawyer do the talking for them.
Good stuff. And Jason, to close things out, if an IME report comes back unfavorable or misleading, what options are available to challenge it, and how quickly does a worker need to act?
Well, they want to move sooner rather than later. The option for challenging it is usually, as plaintiff's attorneys, we have relationships with physicians, all over the state. And typically we can get our clients in with a physician who can render an opinion on that second or the IME report that may be more favorable to our client. But you generally want to have that take place as soon in time to the IME as possible, because if you wait 6 months and then have another doctor see you and physically exam, the defendants will simply argue, well, that's not really relevant because it's not really close in time. So if you are scheduled for an IME, or if you undergo an IME that you feel like really didn't capture your perspective or the amount of pain and discomfort that you're experiencing, like Viral said, it's very important. Come talk to us. We'll give you strategies and help you kind of work around that and do everything we can to mitigate the IME report, and hopefully give the authorized treating physician some ammunition to also attack the IME if they so choose. So typically authorized treating physicians, even the ones paid for and chosen by the insurance companies, since they do have that patient physician relationship, tend to be a little bit more favorable to our clients than IME physicians. So if we can give that authorized treating physician something to kind of help them stand their ground, that can always be beneficial.
Good stuff. Gentlemen, thank you for your time.
Thanks, Evan.
Thanks, Evan.
Alrighty, guys, and that brings us to the end of today's episode of the North Carolina Injury Rights Podcast. If you're dealing with an independent medical exam or have questions about how an IME could affect your workers' compensation case in North Carolina, you can visit MehtaandMcConnell.com or MehtaMcConnell.com to find more resources from attorneys Viral Mehta and Jason McConnell. Thanks for listening, and don't forget to like, subscribe to the show, and leave a review if you found today's episode helpful. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.